The envelope was waiting when I got home, taped to my front door like a warning sign. Bright white paper. Thick. Official. The HOA logo sat at the top like a badge, and before I even opened it, my stomach tightened. This wasn't a friendly reminder or a courtesy notice. This was something heavier. When I pulled the pages out and counted them, my heart sank. 5 separate notices, all dated the same day, all stamped with the same case number. 5 violations. Delivered at once. No prior warnings. No conversation. Just a sudden escalation that felt deliberate, almost rehearsed. I sat at the kitchen table and started reading. The first violation accused me of making an unauthorized exterior modification, pointing to the small security camera above my garage. The camera had been there for over 2 years, visible to anyone who drove by, and had never once been mentioned by the HOA. The second violation claimed my trash bins were left out past approved hours, supported by a grainy photo timestamped at 6:01 a.m., exactly 1 minute past their cutoff. The third violation was more serious, alleging I was running a commercial operation for my home, based entirely on a single delivery truck that had stopped by weeks earlier. I read that one twice, convinced there had to be more to it. There wasn't. The fourth violation accused my backyard fence of exceeding height restrictions. That fence had been installed by the previous owner, and I still had the written approval tucked away in my records from when I bought the house. The fifth notice was the most unsettling of all. It didn't cite anything specific. It simply stated that I was in general non-compliance with community standards. No description. No evidence. No explanation. Just a vague accusation that could mean anything they wanted it to mean. Each page ended with the same warning: daily fines, potential legal action, and further enforcement if I failed to comply within 10 days. By the time I finished reading, the shock had worn off and something else had taken its place. Confusion. None of these issues had ever been raised before. No courtesy letters. No emails. No knock on the door. I'd lived in this neighborhood for years without incident, paid my dues on time, followed the rules as best I could. Yet here I was, staring at 5 violations that made it look like I was some kind of habitual offender. It didn't feel like enforcement, it felt like an ambush. Then my phone buzzed. An email from the HOA board, sent just minutes earlier. The message was short, almost smug. Asterisk, these violations are clear and well documented. Compliance is expected. If you believe this is an error, you may address it during the scheduled hearing. Asterisk, no room for discussion. No invitation to resolve anything informally. Just a date, a time, and the assumption that they'd already won. As I set the papers down, one thought kept repeating in my mind: they were very confident for people who clearly hadn't checked their own rules. And that confidence was about to cost them. The days after the violations arrived were quiet in a way that felt unnatural, like the calm before something snapped. I half expected another envelope, maybe a follow-up explaining the mistake, but instead the silence stretched on. Then the fines started. Each violation carried its own daily penalty, and by the third morning, my online HOA account showed a balance that hadn't existed a week earlier. The total climbed fast, almost aggressively, as if the numbers themselves were meant to scare me into submission. It wasn't about fixing anything. It was about pressure. I emailed the HOA board, calmly and politely, asking for clarification and offering to resolve the issues informally. I attached photos of the fence approval, explained the delivery truck, and pointed out that the security camera had never required approval under the bylaws. The response came back less than an hour later. Short. Cold. Asterisk, all disputes must be addressed at the hearing. Fines will continue until compliance is achieved. Asterisk, no acknowledgement of the documents I'd sent. No explanation. Just a reminder that the clock was ticking and the meter was running. That was when I stopped trying to reason with them and started paying attention. I reread every violation carefully, not as a homeowner trying to fix a problem, but as someone looking for cracks. The language was sloppy. Dates didn't line up. One notice referenced a rule number that didn't exist. Another cited a section of the bylaws that had been amended years ago. The more I read, the clearer it became: these weren't carefully reviewed violations. They were rushed, piled together, designed to overwhelm rather than withstand scrutiny. I pulled out my records and began organizing them. Permits from the city. Emails from past HOA boards. Screenshots of the current bylaws downloaded directly from their own website. I printed everything, labeled it, and put it into a folder. Then I made a second folder, copies of everything, just in case. The more evidence I gathered, the calmer I felt. This wasn't a fight I was losing. It was a fight they hadn't prepared for. A few days before the hearing, another email arrived from the HOA's attorney. The tone was noticeably different from the board's messages. More formal, more legal, but still dripping with confidence. It warned that if the violations were upheld, I could be responsible for additional legal fees and enforcement costs. The implication was clear: show up, lose quickly, and pay up. I read the email twice, then placed it neatly on top of my folder. They were counting on intimidation. They were counting on me folding. What they didn't realize was that by pushing this to a hearing, they'd given me exactly what I needed: a room, a judge, and 10 minutes to let their own paperwork undo them. The courtroom was smaller than I expected, almost understated. No dramatic benches, no raised voices, just a quiet, procedural space where confidence mattered more than volume. The HOA representatives were already there when I walked in, seated together with their attorney. They looked relaxed, almost bored, like this was just another routine matter on the calendar. A stack of papers sat neatly in front of them, thicker than mine, which I suspected was meant to make a statement. I took my seat, set my folder on the table, and waited. When the judge entered, the room snapped to attention, and just like that, the hearing began. The HOA attorney went first. He spoke quickly and smoothly, listing the violations as if reading off a grocery list. Unauthorized modification. Improper trash storage. Commercial activity. Fence height violation. General non-compliance. 5 violations, each delivered with the same certainty, as though repetition alone made them true. The judge nodded and then did something unexpected. She stopped him mid-sentence and asked a simple question about the first violation. Asterisk, which section of the bylaws requires approval for this type of security camera? Asterisk, the attorney hesitated, flipped through his papers, and cited a rule number. The judge looked down, scanned her copy, and frowned. That section was amended 3 years ago, she said. Asterisk, it no longer applies. Asterisk, the first violation was dismissed on the spot. The room shifted. The HOA representatives straightened in their seats, their confidence visibly cracking. The attorney moved quickly to the second violation, the trash bins. He pointed to the photo and emphasized the timestamp. The judge leaned forward and asked another question, just as calmly as before. Asterisk, what time does your own rule define as morning hours? Asterisk, silence. More page flipping. When the answer finally came, it didn't help them. The bylaws allowed bins to be out until 7 a.m. The photo was taken at 6:01. The judge didn't even pause before dismissing the second violation. 2 down. By the time the third violation came up, the alleged commercial activity, the energy in the room had completely changed. The judge asked what evidence supported the claim. The attorney mentioned the delivery truck. The judge raised an eyebrow. One delivery does not constitute commercial use, she said, and asked if there was any business license, advertising, or pattern of activity to support the accusation. There wasn't. The third violation collapsed under its own weight. I hadn't said a word yet, and half the case was already gone. The HOA attorney tried to regroup, but the damage was done. His voice had lost its smooth edge, replaced by something tighter, more defensive. As he prepared to move on to the remaining violations, the judge glanced at the clock on the wall. Barely 10 minutes had passed since the hearing began. She looked back at the paperwork, then at the HOA board members, and her tone shifted, not angry, but unmistakably unimpressed. The next questions were coming, and it was clear they weren't going to like the answers. The fourth violation was supposed to be their strongest. The HOA attorney straightened his papers and launched into an explanation about fence height restrictions, clearly hoping to regain control of the room. He stated that my backyard fence exceeded the allowable height and therefore violated community standards. The judge listened without interrupting, then asked a single question that seemed to drain the color from his face. Asterisk, when was this fence installed? Asterisk, he answered confidently, saying it predated my ownership. Asterisk, And was it approved at the time? Asterisk, the judge followed. There was a pause, then an admission that, yes, the fence had been approved by the HOA years earlier. I was finally invited to speak, and all I did was hand over a copy of the written approval. The judge barely glanced at it before dismissing the fourth violation. No debate. No deliberation. That left the fifth and final accusation, general noncompliance with community standards. The attorney hesitated before addressing it, as if he knew how weak it sounded out loud. He described it as a pattern of behavior rather than a single incident, arguing that the HOA had broad authority to enforce community norms. The judge leaned back in her chair and asked him to point to the specific rule that allowed such a vague charge. He cited a catch-all clause. She read it silently, then shook her head. This clause requires specific conduct to be identified, she said. Asterisk, you can't enforce what you can't define. Asterisk, the fifth violation didn't just fail, it unraveled. The judge looked down at her notes, then back up at the HOA representatives. Her tone remained calm, but the message was unmistakable. She explained that enforcement actions required precision, authority, and consistency, none of which were present in this case. Issuing 5 violations at once without prior notice, relying on outdated rules, and presenting vague accusations was not enforcement, it was overreach. With that, she dismissed the final violation. All 5 were gone. The silence that followed was heavy. The HOA attorney gathered his papers slowly, no longer making eye contact with anyone. The board members stared straight ahead, their earlier confidence replaced by tight, expressionless faces. The judge glanced at the clock again and noted, almost casually, that the entire matter had taken just over 10 minutes. 10 minutes to dismantle a case they had clearly assumed was untouchable. As the hearing concluded, the judge added one final remark. She stated that while the violations were dismissed, she had concerns about the HOA's conduct and record-keeping. Those concerns, she said, would be addressed next. That sentence landed harder than any fine ever could. The HOA had come in expecting a quick win. Instead, they were leaving under a spotlight they hadn't planned for, and the consequences were just beginning. The judge didn't adjourn the hearing right away. Instead, she leaned forward and addressed the HOA attorney directly, asking whether the association intended to continue pursuing fines or enforcement related to the dismissed violations. The attorney hesitated, then quietly said no. The judge nodded, satisfied, and made it official. All fines associated with the 5 violations were voided, effective immediately. Any negative marks placed on my account were to be removed, and the HOA was prohibited from reissuing the same violations without new, lawful evidence. What had started as a threat to my home ended as a clean slate in less time than it took most people to finish a cup of coffee. Then came the part no one from the HOA seemed prepared for. The judge asked me whether I had incurred costs responding to the enforcement action. I explained that I had spent time and money gathering records, printing documents, and preparing for a hearing that never should have been necessary. The judge turned back to the HOA and ruled that they would reimburse those costs. It wasn't a massive sum, but the message was clear: abusing the enforcement process has consequences. The HOA attorney wrote it down without comment, his earlier confidence completely gone. Outside the courtroom, the HOA board members didn't say a word. They avoided eye contact as they walked past me, their expressions stiff and unreadable. A week earlier, they'd acted as if the outcome was already decided, as if I was just another homeowner they could overwhelm with paperwork and penalties. Now, they looked smaller somehow, stripped of the authority they'd been so eager to wield. Their case hadn't just been dismissed, it had been exposed. The aftermath spread quickly through the neighborhood. Notices went out correcting clerical errors. Fines were quietly refunded. A revised enforcement policy appeared on the HOA website, full of new language about due process and proper notice. Within a month, 2 board members resigned, citing personal reasons. The same board that had proudly sent me 5 violations at once now seemed desperate to draw as little attention to itself as possible. I never received an apology, and I didn't expect one. What I did get was something far more important: proof. Proof that intimidation only works when no one pushes back. Proof that rules mean nothing if they aren't followed by the people enforcing them. They brought 5 violations into that courtroom, certain they would win by sheer volume alone. 10 minutes later, they walked out with nothing. No fines. No authority. No credibility. And every time I pass that same front door where the envelope once hung, I'm reminded of just how fast abuse of power can collapse when it finally meets the light.